3 o'clock in Omaha. Welcome back to Communication Law and Policy. We're really excited today to have three of our textbook authors from the Communication and the Law textbook. Three of our authors who have written those edited chapters that we've been talking about this semester. So what I want to do is go to each of them and give them an opportunity to introduce themselves. And I'll just take it in the order of the book. Cayce Meyers from Virginia Tech. And Cayce did the first chapter for us.
Hi, I'm Cayce Meyers, and glad to be here today. Thank you for inviting me. And again, like Jeremy said, my chapter is the first chapter in the book, so it's more foundational. And my research mainly focuses on the intersection of law and public relations practice. So that's where a lot of my own research takes me, and mainly looking at a lot of agency regulations and rules. Most recently FTC type regulations. So it's good to be here, and I look forward to your questions.
We're looking forward to talking with you because the FTC is certainly an area that's been very active in recent years. So as the students think about a topic for the research papers, there's a lot of material there to look at. Greg Lisby is in Atlanta. Greg?
Hey, my name is Greg Lisby. I'm a professor of communication here at Georgia State in Atlanta. My chapter is on intellectual property. As Watt can tell you, and for that matter, as Jeremy can tell you, I've been with this book from the very beginning, and started off doing a chapter on advertising, then one on public relations, and then gravitated to intellectual property. I guess I'd say what intrigues me about intellectual property these days is that intellectual property, whether we admit it or not, is the foundation of all speech. In other words, we do not live in a time where people speak without considering what kind of money they can make off their speech. And therefore, intellectual property law comes into play.
Excellent. And we have Derigan Silver in Denver, UNO's arch rival now in hockey and basketball.
Yeah, we're having a pretty good year in hockey this year, Jeremy. Hi, everybody. My name is Derigan Silver. I came on to Watt's textbook probably 2010, maybe 2009, writing about, really, it sort of comes under the heading of access to courtrooms or access to the judiciary. But there's really sort of three separate issues that we address in that chapter. And one is the ability to sort of attend trials, or when can a judge close a trial to the press and the public. Two, access to documents, which is sort of a subset of attending the trial itself, because a lot of times, we're fighting those battles separately of trying to get into the courtroom versus trying to get documents from the courtroom. And then the third one would be when can you leave a courtroom open but keep people from reporting on what they learn in a courtroom. And so it kind of falls under the sort of rubric of access to the judiciary, but it's a really long chapter, which I apologize for. But it's because there's really sort of three kind of separate issues that you have to deal with anytime you want to cover the judiciary. So thanks for having me, Jeremy. Great to be here. Hopefully we can answer some good questions.
Professor Lisby raised one of the cutting edge issues, but I'd like to go around each of the panelists and identify a couple of trends that you think are important ones for us to watch going forward. Cayce, do you want to start?
Sure. My chapter is again, a kind of a foundational chapter about the legal process. And I think that when we have students that are studying communication law, a lot of times what they think about is they think about the Supreme Court. And I mean, that's appropriate because it's the highest court in the United States, and it has a lot of rulings that directly affect communication. But I think in terms of like, where is communication going, or what are the issues on the horizon? I think that a lot of times communication issues are going to be resolved in agency regulations. And we talked about the FTC net neutrality rule that came out early this year, in January this year. One of the things that it said is that the FTC was going to have a greater role in dealing with online communication and creating regulations. And certainly that's been the case in the last 5 years, that we've seen greater agency involvement. And so in thinking about, where the topics at that maybe are not looked at as much, I would say looking in those kind of agency regs. National Labor Relations Board has some regulations that have come out about workplace speech. And so it's important to realize that, there's a lot of law that's going on, both at the, at the big levels of, high type of attentions like Supreme Court cases, but also in these kind of lesser paid attention to areas such as regular agencies. I'd also add that, Watt and I wrote a book a couple of years ago about Virginia and Virginia laws on communication. And states do a lot of constitutional law, and they do a lot of issues with First Amendment, and there's a lot of case law that comes out of that. So it's not necessarily just a federal issue, but state issues as well. And we can see that in things like social media privacy and regulations on that.
What are the chances that any of these state laws that are responses to net neutrality will survive?
I don't know. I think that people right now don't know what this new net neutrality law is going to do. Of course, the chairman of the FCC says that it's just going to turn it back to the way that it was prior to 2013, and there'll be no difference. And of course, those who are skeptics say that it's going to create this two-tiered system on the internet. That's going to be an interesting issue to watch, and certainly something that is going to be kind of a ripe area for discussion and analysis in the future. I don't know about in terms of the success level of what that'll be. That as time will tell, and I think probably in different states the success will vary.
Professor Lisby, you have a law degree as well. What, from that perspective, what looks different to you?
When you have a law degree, you tend to look at the entire world a little differently. And you tend to ask yourself, what are the upcoming lawsuits as opposed to how people can get along together? In terms of copyright and trademark and intellectual property as a whole, it does seem to me we are in the very beginnings of a period in which we are challenging all of the known concepts. In other words, what is fair use? What is the minimal amount of words that you can copyright? What does it mean for a trademark that has to be used in business? And so we're finding that all sorts of things here are sort of up for grabs again. I was reading the paper just the other day about Wall Street Journal, an article about emoticons and the extent to which they were protected by copyright or not, and for that matter, the extent to which they actually communicate or not. And there seemed to be a lot of disagreement among lawyers about whether they're actually communicative. And so that raises some fascinating questions as far as I'm concerned. The issue of fair use, how much can you use of something before you violate somebody else's copyright? There was a case decided just 2-3 days ago about Taylor Swift and her, and whatever it was, her haters gonna hate phrase. And I can't remember the name of the song, I'm sorry. But the court concluded that there are plenty of songs out there with the same phrase in it, and therefore she was not violating anyone's copyright. So you run into all sorts of things, including this issue of, if it's going to be used in business, does the business have to be sort of ongoing? Can you sort of plan ahead and try to lock things up? Sometimes the answer is yes, sometimes no. And then, of course, my favorite is that we use all sorts of trademark names in political discussion. And yet political discussion does not violate trademark. And Star Wars being the best example of that Star Wars missile defense of several years ago didn't violate George Lucas's protections.
So 2017-18, Professor Silver, was also a year in which journalism itself seemed under attack, whether it be by the president, by Russian bots, if you've read the New York Times story on this. Does any of that kind of feed into the access issues that you're looking at?
Yeah, I sort of feel like, when I was getting my master's degree in journalism, was right before 9/11, and I had a professor who was sort of talking about, right before that we were talking about, is hard news dead? And then 9/11 happened, and sort of hard news came racing back. And I sort of feel a little bit the same way about media law right now. As a few years ago, we were all sort of rushing to research like new technology and how old laws might might be affected by technology, and we were trying to put like a social media spin on everything. And then in the last 2 years, I feel like all the good old fashioned media law has become racing back. I mean, you look at really large punitive damages in defamation cases against mainstream media organizations, or a publication of embarrassing private facts award that basically sues Gawker out of existence. And I feel like in a lot of ways we've kind of come back to what was really kind of basic in the 60s and 70s and 80s is just real tough legal attacks on the mainstream media. And so I got asked this question in class yesterday. We were talking about privacy laws and sort of how ethics sort of overlaps with legality. And I told my students, look, if you look at the 60s and 70s, that's when we got a lot of our really big victories for the media. You know, we got Sullivan, we got, the court kind of lauding the press and all the great things the press can do. And then after that, it kind of went downhill. We had some big losses. People started, rulings started coming back. And, now we're getting courts who are questioning journalism decisions about what is a matter of public concern. And I was trying to say these things go hand in hand with attacks on the press. And these go hand in hand with people's declining respect for and declining trust in the media. And some of those wounds are sort of self-inflicted. Some of those wounds go back to tabloid journalism, and they go back to getting things wrong, being really focused on getting things right. And when the New York Times is publishing fabricated stories for whatever reason, they don't know it's fabricated, but it turns out to be, that sort of attacks the credibility of the press. And the public remembers that, and courts remember that. And I feel like kind of the two go sort of hand in hand, that we are seeing some real tough battles in the courts right now that are sort of being spurred by this administration's real disdain for traditional journalism.
It's been said by justices in the Supreme Court that in the end, it's judges that protect First Amendment rights. Do you think that will prevail in this new look at everything?
So I point out to my students all the time that, judges, federal judges especially, you're looking at older white men. And older white men bring a certain point of view to the law, and they believe a certain thing about the law, and they understand the law a certain way. And that's one of the things I really worry. I love the internet. I love technology. I write a lot about the internet. I write a lot about technology. But I start to worry about judges who are going to lump all communication in together and are going to start saying, well, look at do we really need a sex tape of Hulk Hogan on the internet? But what they don't realize is those rulings sort of extend beyond Gawker putting that tape on the internet to a lot of other types of journalism. And I do worry that if we don't have judges who maintain respect for the press, then we're not going to have judges who maintain respect for the First Amendment.
I'm going to jump to a couple of questions that are in our chat box that you may not be able to see. Nicole Torin asks about, as it relates, Professor Lisby, to the intellectual property chapter, about cases where copyright is disputed with meme use on the internet. She also recently saw Black Panther, where they had a meme line, "What are those?" in the film, and was curious on thoughts about huge production companies using memes and copyright.
Certainly, from a cutting edge standpoint, copyright and memes is right on the forefront of what we're getting ready to start fighting about. Generally speaking, the courts take a straightforward legal position that if you create it, you own it, and most memes are created by one person or group of people, and then they're sort of co-opted and they're made into something else for some other group. And so from a strict copyright standpoint, the second use, at least technically, is violating copyright law. Of course, the question becomes, is it worth your time or your money to go after these people? Is it worth anything other than to sort of, grin and bear it and hope it goes away and stops embarrassing your company or your candidate or whatever? We live in a time where memes are becoming just too many of them to really keep track of. At one time, I thought, oh, here we can probably categorize these, and I've since concluded that no, there's too much out there. Are memes transformative? Which of course is the way you would argue that they are protected by copyright. And I think by and large, in the context, they may be transformative, but the meme itself is simply a video clip, a short loop of something else that is not changed in any way. It is simply how you put it, where you post it. If you post it in your Facebook with regard to, an ISIS video, it has a different meaning than otherwise. And so I think we're almost seeing that people who create memes are perhaps the people who paint walls and paint messages on not billboards, on fences, and these types of people out there who are trying to sort of subvert the standard common message.
We have Mackenzie on video. Do you want to jump in with a question?
I guess going off the whole meme thing, there's some that will use images or some other idea from a TV show or cartoon, anything like that. They use the still image and then they write the like text over that. Is that any violation, I guess, of that cartoon or TV show copyright or whatever, to take that and use it as your own and start a new meme over it?
I guess I'm inclined to say yes. The use of a clip that you put something over changes the clip. Does it change it enough to be transformative? I'm really sort of inclined to say no. I think still you're going to have that idea that that the ownership belongs to the people. As an example, Disney is very, very careful not to let any of its clips of any of its characters be used in any types of political or pornography type of GIF files. And so we're finding as things go on here that we change things, we may overwrite, but we really haven't changed that which is protected by the copyright.
Professor Lisby, I think sometimes I have a sense my students struggle too with even the fundamentals of the differences between an idea and the manner of expression and what's protected and what's not. Could you help us with that?
Well, again, you're talking the fundamental of copyright, that that facts are not protected, history is not protected, but a news article, which is an ordering of facts in a certain manner to present a certain viewpoint, is protected. And so the question either becomes, well, the basic question becomes how explicit, how specific is the reference. The one I always use in my classes to remind students that the sheer number of movies and books and TV shows and so forth that deal with star-crossed lovers like Shakespeare's Romeo and Juliet, none of these really comes close to being the same thing. And for that matter, if my reference is too old, then I pull it forward and I say, well, what about Sylvester Stallone and Rocky? How many movies are there out there about down and out boxers? Well, you can write one anytime you want. I mean, they all have very similar ingredients to them. So that's not protected, but what becomes protected is when you start phrasing and forming things a certain way. And that's where that issue of fair use comes in, because many times we really like to bring the thing we're creating as close to a reference to another one as possible, as an homage, as a way of acknowledging the value of the other one. I'm reminded of the copyright case involving a Mr. Anderson, who wrote the film treatment for, I believe it was Rocky IV, sends it to Sylvester Stallone. Stallone makes the movie, and Anderson gets zero. He gets not a dime because he doesn't own any of the characters. And even though he creates, he didn't have the right to create that Stallone had already created.
Professor Meyers, is any of this being addressed? You mentioned privacy. We talked about some other areas of law at the state level or elsewhere.
It depends, and the point about going to court is is something that we sometimes forget about. I think in our classes is that as an attorney, you would look at it one way, but as the courts, you look at it another. And so when I'm practicing law, I would think, well, is this a case that's going to be successful? Is this a case that's worth pursuing? Is there sufficient money involved in getting damages, something like that? That may be part of the analysis, and then you have the question of what can you legally do under the law, and so sometimes the difference is that people may not want to challenge it because they don't think it's worth their time. And this is not related to copyright, but there have been cases about parody accounts. So you have a parody account of somebody, and it's got a lot of following, and oftentimes these parody accounts have more of a following than the actual person's account. And sometimes in state, you'll see somebody sue over that. Sometimes you'll see people use a different type of strategy, kind of a non-legal strategy, to kind of mitigate the damage that causes them. And the most famous example of that I can think of is there was a parody account in Chicago with Rahm Emanuel, and he started engaging with the account in order to diminish the kind of the negative effects that it had on him, rather than to bring them to court. So I mean, sometimes there's non-legal solutions out there that come about because the litigation expense itself, or maybe the negative publicity from it, is just too great.
Elizabeth Bauman is on video. Do you have a question for us?
There we go. Sorry about that. Kind of in regards to that, I'm not really sure what the following is, and I was just looking it up, of the fake Bo Pelini account that was on Twitter. It's been super popular, I know, especially when Bo was a coach. But because it wasn't ever negative, is that something, I don't know, that I guess would be worried about? Or because it was never like anything negative, and actually like the fan base became a lot bigger, I feel like, because he had so many followers. And I was trying to look up really fast how many he had, but my internet's not really working, so I don't know. That's kind of my question for now. I have some other ones written down, but nothing that pertained to what he just said.
So fake accounts on Twitter, who can address that?
It seems to me that you need to start with a common understanding of Twitter and Facebook and these other platforms. And that first common understanding is that whatever you post on there is no longer yours. It belongs to them. All of their user agreements talk about the idea that it's theirs. This is not public forum. This is private property. And so if you post something on private property, they can do with it what they please.
And I should mention in that regard, we did an assignment earlier in the semester where students looked at use agreements, and George also had a question here just about what could students do in terms of what would they benefit from knowing their rights and their responsibilities.
I thought that we need to revisit our distinction between private space and public space, because modern times, more often than not, many activities that are communicative in nature occur on private space. And I'll just give you a real brief physical example. Here in Georgia last year, we had a Republican rally of state candidates on a private farm in North Georgia. And there was a protester who decided she wished to attend and she wished to have her voice heard. And the argument was, should she be arrested for trespassing on private property because she was not technically invited by the owner? Now, the good news is that every single Republican candidate there recognized that if you're going to kick her off, you're getting into free speech issues. And they were all arguing that she should be allowed to stay, but the police did arrest her. So I guess I'm looking at this saying, maybe we need to revisit a piece of the Constitution that we've not talked about just a huge amount. And that is something called post roads. You remember that section? That's way, way hidden back in the Constitution. But private roads, a bazillion years ago, were made into public thoroughfares because the post riders had to use them to deliver mail. Maybe we need to revisit this issue of what is a private space versus public space that is used for communicative purposes.
Yeah, I think sort of the most interesting kind of recent example of that is the lawsuits that alleged that when President Trump deletes or blocks Twitter users from receiving his information, that because he's using that as a conduit of dissemination of government information, that he's actually created a positive expectation that everyone will have access to it. You guys, I'm not sure which chapter it's addressed in, but the public forum doctrine, that basically through government intent and action, that he's sort of transformed this private digital space into a public forum. And then by blocking people from those public forums, that's actually engaging in a form of viewpoint discrimination. And it's a difficult legal theory. And this is sort of where we get back to the fact that federal judges are typically, white older males who may not understand Twitter or spend any time on Twitter. But when you really think about it, it's not that big of a leap to now sort of look at these private platforms and say, how much public discourse goes on in this private platform? And are we sort of, by use of them, are we transforming them into what we used to consider like a traditional public forum where discourse happens? The legal argument was very interesting. It was a difficult legal argument to make. Some people much smarter than myself wrote briefs in the case. And it ultimately failed. But it does sort of breach this idea. And, there's been some work at the Harvard Center for Internet Policy, the Berkman Center, talking about this. Do we need to start treating these forums differently because of the massive power that they now hold? And there's a great book out there called The Consent of the Networked, which talks about the importance of things like Facebook and Twitter to public discourse and how we sort of need to hold them to a higher standard than what we have been.
Very good. Day Lee has been waiting a while to ask her question.
Hi. I was wondering actually I see you teach courses on the First Amendment, and I'm doing my research paper on the First Amendment on campuses. And so do you think that we can in the future see any of the those rights for students changing as far as the area that they can protest in, or do you think that will probably stay pretty stagnant?
So this is actually one area where I think Casey's point earlier about we love to look at Supreme Court cases, and there's been some really interesting Supreme Court cases about student expression, both in terms of what I was just talking about, the public forum doctrine, and having what they call campus free speech spaces. And when do limiting those become too much? But I think Casey made a really great point about looking sort of to other areas. So, for example, Colorado just recently passed a law that said that all public universities must be considered traditional public forums, and every part of a public university must be considered a traditional public forum. And what this is a pushback from conservative lawmakers who feel like, rightly or wrongly, we can debate this issue, but rightly or wrongly, that college campuses are unwelcoming to conservative messages. And so to stepping in and saying, no, you have to welcome these speakers, you must welcome these speakers, and trying to pass statutory laws that did that. Now, luckily, the University of Colorado pointed out and said, do you really mean every part of campus is open to all speakers? So I can come into a chemistry lab and I can speak anytime I want to about any subject I want to? And the legislature kind of went back and said, okay, well, maybe that's not such a great idea. But it's kind of an area of law where we tend to look at these sort of seminal Supreme Court cases, like Casey mentioned, but there's a lot of action going on at the state level by state legislatures who are really pushing back. And this again goes to sort of what Jeremy was talking about earlier, this sort of negative media message that comes out about certain things, and then you get a reaction to them by lawmakers.
And we have that going on right here in Nebraska as well with the case down at Nebraska-Lincoln. Amaris, do you have a question for us? Maris Groves?
Yes. Hello. Going back to mentioned, I heard viewpoint discrimination regarding as far as like the social media use, but referring to like also in class, like I know that more so in high school than anything, I think college definitely has opened this opportunity and door. But I know that a lot of teachers or professors, like, I feel that they limit students when it comes to like papers writing about certain topics that, you know, that someone's very passionate about, but yet that teacher may not agree with it, so they don't want to hear it. And so I'm just wondering, like, how, like, is that something that I've missed within, like, you know, the university, you know, laws of where they can do something like that? Because that's kind of a personal thing that I've kind of had to go through over the course of my education.
Anybody want to tackle that one?
I'm not aware of any case like that. But I think that again, going back to, you would look at a case like that probably was going to show up in a kind of a state issue. The latest thing that I've seen in terms of viewpoint discrimination or maybe college classroom dynamics is there have been instances where there's terminations, and this goes on both at like a secondary school and college, based on commentary made in classes or something like that. And then the person who's terminated, the professor or the teacher who's terminated, then has to go through these, they go through the Pickering and Connick test to sort of prove that they have been wrongfully terminated. But then again, if you're in a private university, that would be very different. Now, in terms of being discriminated against for viewpoint based on a topic of a paper, I'm not aware of any case like that out there. Not to say that there isn't one. You could probably go through and find one, and maybe someone else on the panel knows.
So I think the cases that are going to be most on point is there's been a couple of lawsuits where students were dismissed for failing to meet requirements of a course. And they argued that failing to meet those requirements of the course was actually protected by their First Amendment rights. So one involved a woman who was part of a family counseling program, and she held the religious belief that homosexuality was a sin. As part of the family counseling program, she had to adopt views contrary to that. She had to take homosexual clients. She had to treat homosexuality as a personality choice. She did not want to do that, and so she was let go from the program. And she sued, saying that was a violation of her First Amendment right, that she was being forced to engage in compelled speech. The court came back and said, no, as a student, you have no right to not follow a program. If you want to be in this program, you are sort of giving up your own views and you can follow that program. There was another case out of, I believe it was Utah, where a woman was in a theater program. And as part of her final grade, she was assigned a play that had a lot of swear words and a lot of curse words in it. She said, that is against my religion. I refuse to play that part. I refuse to say those things. She got an F in the class. She sued, saying this was a violation of her First Amendment rights. And the court said, no, as a student, you have no ability to say, you know, what the course requirements should be. That's up to the teacher. And that's not a violation of your rights to fail out of this program. Those are the two that I remember off the top of my head. I believe there's been a couple more of students being forced to engage in compelled speech, even at the university level. And those challenges on First Amendment grounds have generally failed.
Elizabeth, I think, is still online. She has a text-based question, may want to elaborate on it, but the essence of it has to do with the Freedom of Information Act and national security and that exemption. Specifically, do we determine things, how do we determine confidentiality, security risks, and the like? Did you want to add to that?
Yeah, so basically from my understanding of like the Freedom of Information Act and the national security exemption, they can basically like say that this information can't be released because it's a matter of national security, but is there kind of a standard as to what we hold, like, you know, is it just that they say this is a matter of national security, like the government, and that this can't be released, or is there like some sort of I guess standard that that's held to, or is it just that we have to believe that it's a matter of national security, or do you know?
So under exemption 1, there was a case dealing with this where there was a challenge that there should be some sort of standard of review, that we shouldn't just give the executive carte blanche to say, this is national security information, period, end of story. The court disagreed. The case is called, I think it's Mink, EPA versus Mink, M-I-N-K. And the court said, no, we're going to give deference, that's not our job. The Congress came back and amended that to allow for something called in-camera review. In-camera review basically means that a judge gets to look at the information within their chambers and decide if that's going to be, if that falls under the exemption or not. Even though Congress kind of pushed back a little bit, courts have been unwilling to do that. Generally, courts are very reluctant to make decisions about classified information and national security information. And there's a whole bunch of literature out there. You should look into literature about deference and when courts pay deference and when they don't pay deference. Usually the argument is that courts do not have the constitutional authority to do that under the Constitution, national security decisions are an Article 2 decision, not an Article 3 decision. But 2, judges frequently point out that they're not trained to do that that's not really their job. They're not really in a good position to figure out to do that. My pushback to that is that judges do things they're not trained to do all the time, and it doesn't really stop them from doing it. And it's really sort of one of those interesting areas. So if you look at access to courts, the one area where the Supreme Court has said we have a First Amendment right of access is the judiciary. You have no First Amendment right of access to any other type of information. All other rights of access are statutory rights. Well, so why does the court pick this one area to give you a First Amendment right? Because it's their area. They're cleaning their own house. And so they're not worried about deference, and they're not worried about stepping on the toes of the other branches of government. Recently, you have seen some courts sort of step out, because if you look at Justice Stevens' opinion in Nebraska Press Association versus Stewart, he writes this opinion that's like, whoa, there's a First Amendment right of access. That's great. And I think it applies to all kinds of things. And some lower courts have taken that and said, yeah, we think it applies to all kinds of things too. So there is a little bit of a trend that is moving towards applying this First Amendment right of access to other areas of the law. There's an article by Clay Calvert called Wild Horses Drag Me Away, or Could Wild Horses Drag a Right of Access into Other Areas? Something along, look up Wild Horses and Clay Calvert, you'll find it, where they sort of talk about some of these cases where they're starting to look to apply it to other areas. But generally the judiciary takes a hands-off approach to that, and they show a lot of deference to decisions in that area. And so even though they've been told, like, use an in-camera review, court's like, nope, no thanks, not our job, and we're not good at it, even if it was our job.
To everyone in the panel, we have a new Supreme Court justice last year. There's the prospect of other retirements. Do you see the changing composition of the Supreme Court as impacting First Amendment law in the long term?
I'll take that. Just first, I'd like to piggyback off of something Derigan was talking about, and this is about court access as well. In the media, we hear a lot about FISA courts, and the secrecy surrounding FISA courts. And it's an area that's very controversial. Not aware of how much people really know about them. The FISA judges are appointed by the Chief Justice of the Supreme Court and without confirmation, and they have secret hearings, and they do have a right of appeal, but that's rarely exercised. And so that was just renewed recently by Congress. So that's an area that's very interesting to see kind of the contours of how those courts are being shaped and what do they mean. To go to the question about the changes on the judiciary, of course, any kind of Supreme Court appointment and even lower federal court appointments are going to be they're political processes, and they are subject to that. And so we have President Trump, who's going to appoint presumably more conservative judges, and then if we have a different administration, kind of different types of judges, and a lot of the decisions based on that are come into effect of both who is the president and also what does the Senate look like, what does the Judiciary Committee look like, what does the Senate look like, and can they get confirmation? That's why you had Merrick Garland appointed, but ultimately, he was not confirmed because they held up his nomination in the Senate, but they had a moderate appointment because they figured it'd be easier to get through. One thing that I do think in terms of First Amendment in media is that we have kind of a generational shift, and it's been described this way by a couple of people that I know that are really involved in social media law, and is that we have people that are having social media issues that are typically very young. And then we have lawyers that are typically a little older. They're aware of what's going on in social media, but they're not digital natives. They're someone like me, going on middle age maybe. And then you have judges who are much older deciding these issues. And so I have a Twitter follower that is a judge in Georgia, and he's known as the tweeting judge. And he's like the one guy that tweets. So he's the one guy that really interacts with the interface to understand the contours of the technology. Now, as the judiciary changes and they age out, you're going to see, I think, maybe a change in terms of the understanding of the technological issues, because the people themselves are more familiar with it and more engaged in it and maybe understand the implications of it, rather than having someone that understands the law and they kind of try to conform the technology to what the existing law is without really appreciating the technology or its impact.
In that regard, we just briefly touched on privacy at the open. What about data in the social media spaces and data privacy? The European model is quite different on this. Does anybody on the panel see the United States looking more at that? I know Justice Kennedy is sort of a globalist, but he may be retiring. Is there any possibility at all that we'll be re-examining privacy in the law?
Well, I've done some work on the right to be forgotten, so I'll touch on that. And I don't know that we could, in this country, have a right to be forgotten like Europe has, that it wouldn't violate the First Amendment. Because in the right to be forgotten, you have situations to where a person can request that something be digitally removed from the press that is a legitimate news interest, because the whole genesis of the right to be forgotten movement was a man who had 2 articles published about his tax sale for deficient taxes, and he 10 years later wanted that removed from Google search because he didn't like that being out there. So I don't know that we could really get to that level of privacy on the internet. And of course, the European concept of privacy is much different than the American concept of privacy. So, but again, that does raise some questions of what are the contours of privacy when you have people, one, self-disclosing a lot more than they used to, and the implications for that. And then 2, what about these social media sites that gain such aggregate amounts of information? LinkedIn, for instance, has so much information about its users because it's the professional website and everybody puts all this stuff on there. And what can they do with that? And what is the value of that? And what is, what are the protections for the users?
The big one that gets me for privacy, so there was a really interesting case. I'll say 2 things just very quickly. There was a really interesting Fourth Amendment case a little while ago about how long could you put a GPS tracker on an individual's car before that became an unreasonable search and seizure. if I get a warrant, warrants are supposed to be narrow and specific in their scope. And when I serve a warrant upon you, it's supposed to describe what I'm looking for and where I think it is. And so the question was, if I just put a GPS tracker on your car and I just leave it on there forever, is that a violation of your right to privacy? Is that an unreasonable search and seizure? And Justice Alito wrote a concurring opinion, and I believe it was Justice Sotomayor wrote a very interesting opinion that were very nuanced and talk about privacy in the digital age and talk about new conceptualizations of privacy and data privacy. And they were really great opinions. And then Scalia wrote the majority opinion, and he said, in 1786, privacy was space, and your car is a private space. And if you put something in this private space, then you're violating privacy as we understood it in 1786. And it was this really interesting example of, two opinions that were they kind of brought up all these issues and sort of made you very hopeful that the court would take this nuanced approach. And then the majority opinion was like, nope, what was privacy in 1786? And that's all privacy is going to be today. And it's sort of a question of whether we kind of evolve along those lines or we don't. The big question, the two questions I get, especially with digital media and privacy, are come up because of doxing cases and come up because of the recent Hulk Hogan case. And they deal with what involves a matter of public concern. And under privacy torts, typically you are protected when you publish newsworthy information, even if it's private. If it's of a public concern, then you're protected. When you start looking at some of these doxing cases and some of these outing cases, and believe me, I'm no fan of Nazis. Duke and the Nazis, they're about the same level. But when you look at people who are outing and doxing people for participation in public rallies, I'm not sure that's not publication of embarrassing private facts. I'm not sure that is not a non-newsworthy private information that would be highly offensive to a reasonable person. And then you combine that with the recent decision, the Gawker decision involving Hulk Hogan, where there was two different matters. There was the matter of the existence of the sex tape, and there was the sex tape itself. And the judge said, look, the existence of the sex tape might be a matter of public concern. The sex tape itself may not be. And they left that as a question for the jury. Was viewing the sex tape itself a violation of his right to privacy because it was non-newsworthy? And the jury said, yes, that's non-newsworthy. Viewing this sex tape about Hulk Hogan, actually viewing him having sex, is a non-newsworthy private fact. Now, the fact that the sex tape exists may be of a public concern. And I think that's what I think with privacy is very interesting, is our judge is going to start stepping in and saying, look, the internet's gone too far. Bloggers have gone too far. We are now making everything private public. And just because you find it titillating or interesting does not mean it's a matter of public concern.
I also have the nagging feeling that as we further enter the age of the Internet of Things, that Alexa listening to us and, development of further bots and the use of the data in different ways is going to open up some new questions. Shelby, you've been waiting a long time. Do you want to ask your question?
Yeah, can you hear me?
Yes, we
okay,
can.
Perfect. A little bit of question that also kind of goes with the privacy, so to speak. I'm going to look into doing, previous to this semester, I did the Snapchat terms of service. So I want to do Snapchat and defamation. So I was just kind of wondering if anybody has any kind of information on maybe cases that I should look up in particular, or anything along those lines that can, kind of help me lead towards my research.
Anybody found any Snapchat law cases?
I know 2 Twitter defamation cases. Courtney Love has been sued twice for defamation via Twitter, which some people call twibble, which I think is twearable, but that's a different story. So she was sued by a former lawyer for defamation over Twitter. She made some comments basically saying that it's a really interesting case, because she was saying there's a lot in there about defamatory content, and when you post something on Twitter, she basically said that her lawyer was sort of on the take or in the bag, and the court said, well, in the in the context of Twitter, what does that mean? Does she literally mean that she was receiving money from the opposing side? And the court said, no, it's rhetorical hyperbole. She didn't actually mean that, but it could still be defamatory. And then the other case involved an NBA referee where there was a reporter in the stands, and there was a hard foul on one player, and that wasn't called. And then another player came back and made another hard foul, and the person said, "Well, that's refereeing in the NBA today," and the NBA ref sued. And what you're really looking at there is the question of publication. And publication is a term of art. And anytime you publish anything, be it via social media, as long as one other person receives that information, it's considered published. So those are probably, I'm not aware of anything involving Snapchat, but those are probably the closest cases, is the ones involving Twitter. There's also several involving Facebook.
I'll just add to that there are some international cases on that as well. In the UK, there was a tribal case brought against Sally Bercow, who is the Speaker of the House of Commons' wife, for tweeting out, insinuating that there was a former member of Parliament who had committed some crimes back in the 80s. And then the Courtney Love cases, I believe there's another one about where she had defamed her dress designer, and that she had said that this dress designer had stolen money from her and not delivered goods, and this woman had an Etsy account, and that was affecting her Etsy sales. And that is, I don't know how to say it. I think it's Simorangkir versus Love, but it's SIMORANGKIR v. Love in 2009. And that's out of California, talking about, just somebody going on a rant on social media and creating a lawsuit as a result.
Yeah, and speaking of rants, which makes me think of our president and how he likes to rant on Twitter. He was actually sued for statements he made about a woman who came out with negative statements about him. And he tweeted that she had been trying to get a job with his campaign for years, and this was sad. And this was just her getting back because she was terrible, and he had a meeting with her, and she was a terrible candidate for the job, and she was just being vindictive now. She sued for defamation, and it was actually really interesting because what the judge ruled was, if you take the context of the tweet into mind, nobody, and these were his exact words, he basically said, nobody takes anything the president does on Twitter seriously. It is ramblings, it is rants, it is not meant to be understood as statements of fact. And therefore, under current tests for opinion, no one would take this as a false statement of fact, because on Twitter, people rant, and that's what they do. And so it was sort of a very interesting opinion because it went beyond sort of the case itself and kind of looked at Twitter as a platform and how should we be looking at communications on Twitter.
Professor Lisby, this kind of, I think, brings us back around as we get down to our last few minutes here to this idea, presented early in the book, which is that political speech is at the core of how we understand the First Amendment. And we've had a question, I think, in text by Mackenzie kind of relating to the gun control debate following the high school shooting down there. When it's mediated communication in places like these social media sites, does it change at all in your mind the nature of the protection of political speech?
Yeah, I'm inclined to say no, it does not. Mediated communication can be mediated from a newspaper, for TV station, social media, wherever. I think the challenge we find these days is that we are all speaking more euphemistically, and we're not really saying what we think sometimes. Now, I recognize that there are some, including our president, who does say what he thinks, but many others will sort of try to dance around it and make it much harder to figure out. And then, of course, claim that it's not public speech at all. It's a matter of opinion or private information or something. I find myself, even in the areas that are considered to be private speech, to think of these things as saying that you want to have public speech, you want to have political speech, you want to have speech that we can all engage in that's not necessarily restricted by either trademark or copyright. And yet what you're finding is that many times the discussion we get into starts getting interestingly close to that. You know, the movie The Black Panther is commentary about the Black Panther and its popularity. Is that political speech, or is that something else entirely? We find all sorts of meanings in all sorts of media today, whether they may have actually been there or not. The reviews of Black Panther, as an example, I'm convinced that they meant every one of them, and they've done a great job of pulling together an interesting storyline that Marvel let languish for years and years and years. But when you think about what is public, what is an issue of public interest, I'm reminded that the early case law involving broadcasting goes back to grain elevators. That's the 1890, whatever it is, Munn versus Illinois case. And we start finding private things used for public purposes. And in some ways, we're living in a society that maybe we got rid of the fairness doctrine too quickly. Maybe we got rid of this idea of being public, of being in private space too quickly, because the whole concept of what is private physical space is changing. So I'm thinking that more and more stuff is political, whether we like to call it that or not.
We have just enough time left for closing remarks, so let's go back to Virginia and Professor Meyers.
Well, thank you for having me. I've enjoyed it, and I hope I gave some help to students. I think that going forward, we're going to see a lot of changes in terms of the contours of what privacy is, and I think that it's important also for people to, we had a discussion earlier about what is social media and what kind of platform can that be, and understanding the contours of a public space and a private space, and understanding what those regulations can be on social media. I was reminded of a case out of Pennsylvania where a person was trying to sell their social media account, their limited license, for something like, it was a LinkedIn account, for $150,000. I'd like to have a LinkedIn worth $150,000, but I don't. But so these kinds of new issues are coming up, and the law is always trying to put them in the context of the existing law, and that's really going to be the struggle. So if you find a topic that kind of intersects those kind of new technologies and new realities with existing laws, that's a really ripe area of research, and I think that you can make a lot of hay with that. So good luck to everyone in the class.
Thank you. Professor Silver?
Thanks everybody for having me. It's a lot of fun. It's great to get your questions. Keep your eyes open. I mean, this is it's a tough topic. Luckily, you have a professor who I think brings a lot of new ideas and a lot of new ways of presenting information, and tries to keep it lively for you, and that's going to help things. But it's a really important topic. It's an important topic because lawyers out there believe that they have magical letterhead, and they believe that they can scare you into doing things simply because they send a letter and it has the word cease and desist in it. Many lawyers have never taken a First Amendment law class and don't understand what your rights and responsibilities are. And so knowing those is going to go a long way. As far as research topics, find something that you are interested in. Don't try to figure out what your professor is interested in. Don't try to figure out what's going to be an easy paper. If you're writing a paper your professor's interested in about 5 weeks, you're going to be cursing his good name, and you'll probably be defaming him in all kinds of ways. But if you find something that you're interested in, it'll make the paper a lot easier to write. And the biggest complaint I get from students when I assign them papers is you only gave us 10 pages. It's too interesting. I can't cover it all in 10 pages. And if you find a topic you like, 10 pages is going to go by like that.
We're also looking for 10 pages. That's perfect. Professor Lisby, you and I think have gone back the longest on this panel. I know we go back decades, so I'll give you the last word.
Okay. Well, it seems to me that when you're talking about First Amendment, there are two areas that really catch my attention that I think are very worthwhile. One is this idea of compel speech. What can you make someone say or not make someone say? I'm finding there's a case that's before the Supreme Court right now with regard to a lawyer who's being sued for legal malpractice because he admitted that his client killed a person, and the clients told him you are not to admit that. The lawyer's argument was that he had to admit it in order to get the jury to buy that his client was insane. And so we have an interesting question here. Can the lawyer overrule the client's determination in order to save the client's life? Can the lawyer choose his speech to make the client do something different or to help the client in some way? And I find the idea of compelled speech to be just really fascinating. The other side of this is the idea of the First Amendment being offensive. I'm finding today remarkably large numbers of people who posit a really sincere and extensive offense based on something someone says. And you think, are we really being offended, or are we simply making a racket to try to get them to hush up? I think really we need to go back maybe to the John Stuart Mill and Jeremy Bentham approach to the First Amendment and try to expose ourselves to things that we know we disagree with, to attempt to analyze it from a logical standpoint. And I guess finally, and just to sort of end it up there, I would say the biggest problem I have is that we're really trying to make all this speech out there things that you can own. And it is amazing to me the number of things we say, oh, this is mine, I created it in some way. So it's an area that I find fascinating, and I've found it fascinating for 25 years, and it's still out there. Most recently, as I think I told you about the Wall Street Journal article, what about emojis? Not just are they protected, but let's go from a communication thing. What do they mean? So there's great stuff out there. I hope you always enjoy your research, and it's one of my favorite classes, always has been.
Long live the marketplace of ideas. Professors Meyers, Lisby, Silver. I didn't have $150,000 budget for this, so that I'm sorry about, but I do really appreciate, and we appreciate you taking the time to do this. It was kind of a voluntary ask kind of a thing, and it was really nice for you to do that because I think it really helps the students get a better sense of who's writing what we're reading here. I think it just brings it more to life for them. So thanks to everybody. Thanks to the students who asked some great questions. And we will stop this for today because we're out of time, but I will certainly share the recording to everybody. So thanks again.